All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Seated. Good morning. We appreciate y'all being here. We have had the opportunity to review all of your briefing, and we only set cases for oral argument when the court has some particular concern about some of the legal issues or we have disagreement among the justices. So we're expecting really good arguments from y'all today, and I appreciate your preparation. And Madam Clerk, if you'll call the case.
In case number SC 2025-0372, Michael Jerome Jennings v. Christopher Smith, Justin Gable, Jeremy Brooks, in the City of Childersburg. This is a certified question from the United States District Court for the Northern District of Alabama, Eastern Division. Arguing for Michael Jerome Jennings, the Honorable Harry M. Daniels. Arguing for Christopher Smith, Justin Gable, Jeremy Brooks, in the City of Childersburg, the Honorable Ed Haddon.
All right, Mr. Daniels, are ready? You may begin.
Good morning. My name is Harry Daniels. It's an honor to represent the appellate, Pastor Michael Jerome Jennings, in this matter, as well as to argue on behalf of the people of Alabama protection their constitutional rights. Your Honors, I'd like to start by saying freedom cannot thrive under the capricious demand of the state. The entitlement to live one's life free from unwarranted interference by law enforcement or other governmental entities is fundamental to liberty. Interpreting Alabama Statute 15530 as permitting arrests for failure to present physical identification would fundamentally distort that principle, encourage misuse, undermine public confidence, and bestowing upon the government a power that our Constitution was intended to restrict. Going right into this argument, Alabama Code Statute 15530 is clear and unambiguous. This matter was set before your colleagues at the 11th Circuit, and they stated that the statute was so clear that no reasonable officer could believe that the statute requires ID or a driver's license in an investigatory reasonable suspicion stop. And to emphasize on this particular statute, this is a statute that's really a codification of reasonable suspicion, Terry versus Ohio, where an investigation can go forth in a particular matter. And when we're talking about reasonable suspicion, and we're talking about the bed.
Let me just stop you there.
Sean,
would you agree that this was a Terry stop?
I would agree this was in fact a Terry stop.
And it was a valid Terry stop.
I would agree this was a valid Terry stop. The neighbor, in fact, said that she believed a person could possibly break in. Argument could be made that was dispelled once the officer got to the scene, but I would agree that it was a valid Terry stop in this matter. And in a Terry stop, we're talking about investigation. We're talking about investigations to whether criminal activity is in fact in play, which is reasonable suspicion, which the Constitution requires, the Fourth Amendment of the Constitution requires that probable cause to be in effect where an officer or the government can in fact get to documents and papers. I would say that the law license or ID would constitute as documents and papers.
Let me stop you there. The Hibel case from the U.S. Supreme Court, that was a Nevada case, right?
That's correct, Your Honor.
And the U.S. Supreme Court said that the officers there did not violate the Fourth Amendment, right?
That's correct. They did not.
And they were asking for the license in that case, right? A document.
There was asked for a license, but the court in the Supreme Court did not go beyond and extend and say they in fact can get the license that they can identify him on that reasonable suspicion. And if a state if a state has a stop and identify, it would not abridge the Fourth Amendment if they are asking solely the name. But the Supreme Court in that case really didn't extend or really didn't give an opinion as to where IDs or documents in fact could be ascertained on a reasonable suspicion.
But those were the facts of the case, right? They got the driver's license, they asked for the driver's license, and the U.S. Supreme Court said that was not a Fourth Amendment violation.
They said it was not a Fourth Amendment violation as it relates to providing the name, but the facts in the case did identify, particularly receiving driver's license. But when you're looking at the facts in this case, and I think the application of this statute really need to be examined. We have all these briefs before you, all these amicus briefs, the appellate and appellee's brief, but really the application of this statute, how this statute applies. This statute needs no interpretation. This statute gives law enforcement all the authority it needs when they encounter an individual who's not willing to give information. The statute says you give name, address, and explanation for your action upon reasonable suspicion. So if a person don't give that information, law enforcement could in fact arrest a person for not giving that information, for obstruction of government operation.
Where does it say that in the statute? Because we've got
What-
this one statute that's up there. It just says they may demand.
Well, the statute said they may demand, which they can demand those three things. However, if law enforcement is given a directive by the state that they can demand information and that individual do not provide, there's other statutes and laws within this state that allow obstruction. Now, I know, and recently, as last year, the legislation pushed for this House Bill 34, which died in the legislation, which I think is scheduled to be read in next week. And
Mr. Daniel?
sorry.
To interrupt. I wanted to follow up a little bit on Justice Seller's question. Thinking about the statute at issue, let's assume that the suspect doesn't give an obviously false name, doesn't outright refuse to give any information, but instead responds to the police officer's request in ways that are themselves suspicious. For example, the suspect shifts back and forth on his feet and stutters a little bit and finally comes around and says, "My name's Greg Jones." That's right, Greg Jones. I'm not Mickey Mouse. I'm not refusing outright. What would, on your theory of the statute, what would the police officer supposed to do in that scenario where you're given a suspicious answer to a question that the officer is entitled to ask about?
Well, I think the officer, within the bounds of the law, that they can continue the investigation. That's why this investigatory stop as to whether this name information to alleviate that suspicion to the extent, and you have systems in play. And I think my friend on the other side talks about.
So they could ask follow-up questions?
They can ask follow-up questions.
Should they ask for the ID?
Well, they can ask for ID. The question is, can they compel ID? And the officer can ask for ID initially when they approach the person. They can ask for it, but the question is not whether they can ask. The issue is not ask. The issue is demand. The statute doesn't require them that they can compel a person ID. And I think a good officer to it in an investigation could ask for ID in that situation. Well, do you have identification? If the person don't have identification, continue to ask. And when you look at this statute, the name is not the only element in this particular statute that identification could be made. It talks about address, the person's address. What is your address? So address is also, I believe, is a data point where officers can use to match and see if this is that person, the name that's given. Particularly when you go into the system, if you're running for a particular, see if this person have a warrant or outstanding warrant or any other thing, putting that information within the system. So, for example, the officer asks for a name. They give the name, but they don't give an address. Well, the statute also demands that you get an address because that name could be, we could both have the same name, same exact name. It's a lot of people have the same name, but we more than likely don't have the same address unless I'm a junior, senior.
Mr. Daniels, so let me ask you this. My recollection of the facts is that the gentleman gave his name as Pastor Jennings.
Correct.
He said he lived across the street.
That's correct.
So is your position that with that information, they could have run his name and found out if he had an outstanding warrant, for
No,
instance?
that is not the appellate's position that they could have ran his name with that information.
Okay.
However, in the fact that they are entitled or they could ask for his name, they never asked for his name. And in fact, when you look at the video that's produced by the appellee, the appellates, I'm sorry, the appellee, when you look at the video, they clearly wanted his driver license identification. They talked about with the neighbor. Well, if he just would have provided his ID and told us why he was here, all this could have been avoided. In the report, they put in a report, he didn't provide his driver's license. And at the beginning, when the officer approaches Pastor Jennings, he say, "Well, yeah, I need your ID." So the answer question, Chief Justice Stewart, Yeah, they couldn't run the information, but they did not try. You know, it's good to try before you pry. And the statute is in place here to give a law enforcement the tools in order to ascertain the information. Particularly if a person, if he like, well, Pastor Jennings, that's your title for the church, and I understand that. But Pastor Jennings, what's your first name? And in the video, when they finally asked him, well, what's your name? He told, my name is Michael Jennings. They never asked that, and that's what the 11th Circuit pointed to. They never asked the fundamental questions. The easy question, if any officer want to identify an individual, the fundamental question is ask, what is your name? They didn't do it. Now
He refused to provide identification, didn't he? I mean, when they asked for the driver's license, he immediately said, I don't have to identify myself. That's what he said. I don't have to identify myself. So he understood the request for the driver's license as identification. And he said, no, I don't have to identify myself. So yes, they might not have specifically asked the question, but he certainly understood what they were asking.
Well,
If I can
I think that
Can I interrupt you before you answer that? I'm sorry. But prior to that, he had given his name, not his address, but said that he lived across the street and also provided an explanation as to why he was there. Is that correct?
he said it was their ward and his name was Flowers.
Okay. Which meets the terms of the statute.
Right. And the 11th Circuit kind of opined that he seen what met the statute. And I'm sorry, Judge, what's your question again?
Yeah, he immediately after they said, they asked, hey, what were you doing? He gave him a very short answer. My name is Pastor Jennings. I live across the street. I'm ordering some flowers. And then they said, for the follow-up, they said, do you have identification? Do you have, I forget they use the word driver's license. And he immediately became hostile and said, I don't have to identify myself. So he understood, didn't he, that they were asking for identification information, whether they ask it in those specific terms or not, and he refused it. So do they have to ask for it in the specific terms if he says, I'm not going to identify myself?
Just I think
If I can jump onto that, I would add to the question that as I watched the video, he says, I don't have to identify myself. Alabama's not a stop and identify state.
Yeah.
And then he walked away and eventually even basically said, the officers, arrest me. This is what I want here. I'm almost welcoming this to bring a lawsuit. How does, it almost seems like he has, by his own actions, shut down any question of any kind of identification. What am I missing?
Well, I think you look at the context. So he obviously, I think Justice pointed out to it that he identified himself as Pastor Jennings. He lived across the street and he was their ward and neighbor's father. So when you look at the context, he's willing to provide some identifying information of who he is. But when the officer say, well, yeah, but I need you like your ID or driver's license, then he say, I don't have to identify myself particularly. And I think an argument could be made, and this is a position of our client officer. This is not a factual case for position here, but the issue was not, he was not willing to give his information, his name. The issue was driver's license or physical identification that we pointed out in the district court as well as the 11th Circuit. The issue was not that I don't have to identify myself at all. He's already identified himself. He's already identified. The officer didn't take the initiative, the investigatory initiative to ask, what is your first name, Pastor Jennings? So that would be our position on that.
I think we're somewhat getting into the weeds here because the question before us is whether or not the statute, as it comes from the federal bench, does the statute prohibit the officer from demanding or requesting physical identification?
Thank you, Your Honor.
Speak to that.
Well, as a question posed to this court, I think that the statute does not prohibit an officer for asking for physical identification. Like I stated before, you can ask for blood type, you can ask for whatever you want to if the person is willing to provide that information. But where we're different from the issue as to whether the officer can demand that information, and that's where we get into the arguments about arbitrary and capriciously, and we talk about vagueness. That really, at that point, if an officer, you give an officer information, hey, my name is Justice Wise, and they take that and say, well, okay, let me see your ID. I need your ID. Well, what prevents the officer to say, okay, your name is Justice Wise. What is your first name, Justice Wise? Before you go to that next level, well, give me your ID. Justice Wise is incorrect and unsatisfactory. And what it really creates, it creates that the citizens of Alabama, people born within the state of Alabama, having to carry ID everywhere. If you choose to go down to the corner store and leave your wallet in your chambers, your ID in your chambers, you're subject to being arrested if there's some type of real suspicion or somebody say that you are engaged in some type of possible criminal activity, all because you don't have your ID. And I know that the other side is talking, well, nobody wants that. But the statute, if it's interpreted the way the question is being posed, it opens up for that to happen. Because now you're giving officers the ability to interpret what is incorrect, what is unsatisfactory. That's the issue that happened in the Colinker case when the issue for the Supreme Court was reliable. Well, it gives the opportunity for officers to say, I just don't think your name is that. And let me see your ID. If you don't have ID, then I can arrest you because you're in violation of that statute.
Would you agree with me that if we were applying Terry principles here, and I ask you for your information, because the Hibble case says I can ask you for your information consistent with the Fourth Amendment. I ask you for your information, and you give me information that's incomplete. I can follow up on that, right?
Correct, Your Honor.
Can I follow up on that by asking for your ID?
You could, and you can ask for the ID. You can ask. The issue is not the ask. The issue is the demand.
And let's say you don't give me the ID, and you don't give me a complete answer to your identification, and I've got a valid Terry stop, and I've tried to follow up on it. Can I arrest you then?
Well, I think that goes into more than arbitrary and capricious. That's an officer doing a thorough investigation to try to identify. But when you look in the context of this statute, that's not the name. We're talking about address. So it's other things that could possibly identify that person. It's even to the extent the explanation of your actions. The explanation of your actions could also lead to identify, what are you doing here? Who are you? So I think that the question is, can they ask in its totality, when you look at an investigatory stop to determine if criminal activity is afoot, and once the officer asks those questions, try to identify that person, and they just simply can't, then it gives rise over to potential probable cause.
This was a second step, though. He asked him, hey, what's up? He gave him some information, and it wasn't complete information. And his second step was to ask for the physical ID. Now, maybe a more precise second step would have been, a more smaller second step would have been, okay, we'll give what's your name, full name, and what's your full address. Maybe that would have been a more precise second step. But it's a second step here. It's not the first step. He didn't come up and immediately demand the physical ID. He initiated the conversation and got some identifying information. And Pastor Jennings obviously understood he wanted some identifying information. He just gave him incomplete identifying information.
Justice Cook, I think that looking at the video, that when the officer wanted to identify Pastor Jennings, his identification mode was ID. And Pastor Jennings freely gave that information over to him, particularly his name, address. Well, he lived across the street, and his state was there, but the officer wanted an ID. And when you look at the totality of the video, and I know that, we kind of Monday quarterbacking this thing, looking back, hindsight 2020 particularly, but when you look at the entire video, their sole focus and goal is to get a physical ID from him. They said at the end, when they're talking to the neighbor, and they put it within the report that he failed to provide driver's license. Because at some point in the video, he in fact tell him, I'm Michael, Jennings.
That was after they had arrested him.
That was after they arrested him.
Your time's expired. Thank you so much.
Thank you.
May it please the court, Ed Haddon for Officers Smith, Gable, and Brooks in the city of Childersburg. I'd like to go, Justice Cook, to what you and Justice Parker were talking about. And I'd like to cite you to the Hybel decision. I think that's how you pronounce it, Hybel, page 185. And in that decision, it says that you can satisfy the statute either if the suspect either states his name or communicates it by other means. And a driver's license would be other means.
Was Hybel a traffic stop, or was it an otherwise?
No, sir. It was an assault case that a man had assaulted his daughter, and so he was in a truck, but he was stopped on the side of the road, and they stopped him there.
So trying to understand here, the Fourth Amendment under Hybel, you would argue, allows them to stop him in a Terry stop, ask for a driver's license, and arrest him if he doesn't give it to him?
Yes.
Mr. Haddon, this is not a Fourth Amendment case.
Sorry.
This is not a Fourth Amendment case. This is a 15-530 case, right?
Correct, Your Honor. However, that statute, based on reasonable suspicion, has been interpreted by the Alabama Court of Criminal Appeals to be consistent with Terry, because it asks for a reasonable suspect, so you have to have a valid Terry stop before it kicks in.
Right, but the question isn't whether the Fourth Amendment was violated here. That's not the question that we got from
It's
the federal
authorization.
judge.
You're right. Authorization. And so what we would say, does this statute authorize a police officer who's made a valid Terry stop to get a driver's license? Okay. We say yes, and here's why. That statute.
Does it matter to you whether they can demand it or just get it?
It does matter. The statute says demand. And so demand means, we believe, that the officer has the right to get it,
Okay.
not just ask. He has the right to get it. And I think
To get the actual driver's license, not the information that's in the last part of the sentence.
we would say that the information is name, address, and explanation of actions. No question about that. That's plain in the statute.
But before you get to that, the statute says, whom he reasonably suspects is committing, has committed, or is about to commit a felony or other public offense.
Right.
At that point, he can demand.
Right. Once you have that, that's the Terry stop. You have reasonable suspicions of that, then you can demand. Not before that. Because if you're just a member of the general public and you're not a criminal suspect, you can walk away and you don't have to answer any question for a police officer. But once you're a criminal suspect, based on articulable facts that are reasonable, then you fall into this statute, and Hybel would say, and 15530 would say, you got to answer that question.
And the suspicion came from the phone call from another neighbor who said there is a vehicle and a suspect, and the neighbors around the town.
Yes, Your Honor. The 911 call, plus when they got there, he said he didn't live there, and there's a no trespassing sign on the house. And so all of that together gave reasonable suspicion.
Okay, thank you.
Okay, but Chief Justice Stewart, back to your question about where do you get the driver's license out of here? Okay. The statute does not deal with or address or limit the police officer to a medium or the type of document or type of conveyance of that information.
Okay, so could he have demanded their passport?
He could, Your Honor, but here's...
And then if he doesn't give it, he's going to be arrested for obstruction of justice?
Well, that gets back to what is our test? And a good question. So what we would say the test is just like Terry. We want an objective test for not the specific police officer's personal predilections, but the reasonable officer. That's Terry. And we would say it's on the totality of the circumstances. Well, most people don't walk around with their passport, okay? But most people do walk around with their driver's license. And so we would say the test is whether a reasonable officer, under a totality of the circumstances, took reasonable steps to determine the true name, address, and explanation of actions of the criminal suspect.
Mr. Haddon, I was reading the Edgar case from the 11th Circuit, and it makes reference to a code section. It's 3269. The caption is possession and display of license. I presume you haven't got it memorized, but it says something along the lines of every licensee shall have in his or her immediate possession at all times when driving a motor vehicle and shall display the same upon demand of a judge, peace officer, state trooper, etc., that license. Curious what you make of the fact that the legislature has actually in a separate code section sort of specified exactly what they want, and how that informs the argument you're making here, where there's the textual basis may not be quite as direct.
Well, I think it makes perfect sense what the legislature did, Your Honor, and here's why. The only documentary evidence that shows that I have passed the written exam and the road exam to drive a car in Alabama is my driver's license. However, with respect to name and address, there's tons of documents that show that. One is your birth certificate, at least it shows your name, your marriage license, the deed to your house, a utility bill, your voter registration card, and your driver's license. All of those show that. And so it made sense that the legislature did not limit a police officer to what one type of document to get a name that is ubiquitous on numerous documents. Because a police officer has to take a criminal suspect as he finds him. And it might be driving a car, it might not be. And so he has to then take reasonable steps in order to determine what that name is. And we would say, Chief Justice Stewart, to verify that name.
Did he have his driver's license with him when he was arrested?
No, Your Honor, he did not. And here's what we would say about that. If you have a situation in which a suspect, he's a criminal suspect, and the police go up to him and ask, I want your driver's license. He doesn't have it because he's walking his dog around the neighborhood. Okay, well, can you arrest him and throw him in jail for that? And we would say, no, you can't. And the reason why is because to arrest somebody, you have to go to the obstruction statute. And the obstruction statute says you must intentionally obstruct. And intentional obstruction does not mean I don't have it, so I can't do it. I'd be glad to give you, but I don't have it. That's not intentional. But what is intentional is what Mr. Jennings did when he just refused to give his name. I'd like to follow up on what my opposing counsel said, because we actually...
Mr. Haddon, I want to ask you a question right quick over here. Sorry.
I'm sorry.
But I didn't get a chance to ask the appellant, and I hope to do that when he comes back up. But does this just come down to what the definition of demand is? And does it include, you've used the term demand and verify and that sort of thing. So is it your position that demanding name, address, and explanation of actions either includes verifying the answer or just means optional ways? If I demand it, that can mean I ask for a verbal response, or it can also mean I ask for a physical response of showing the license. Speak to that just for a second, if you could.
Your Honor, here's what, and I think that gets a little bit into the Colander case, and I want to talk about that. Okay, so our position is that he gets to demand. Demand means you get to get it. And the police officer, we think, can demand a physical driver's license. And if he has it, we think he has to give it, or he's going to get arrested for not doing that. And we think that's consistent with the Heibel case, which at page 185 says name or by other means, communicates the name by other means. Now, in the Colander case, Justice O'Connor said that the problem with that statute, the California statute, was that you had a couple problems. One is it said identity, and the California attorney at the U.S. Supreme Court during oral argument said that the police officer at the scene, not the reasonable officer, but that specific officer at that scene, could then take a look and say, okay, well, I want this. I want the explanation of what route the jogger's running, or I want his driver's license, or I want his name. He could do anything. So the police officer could define the offense. And they said that the officer can't be the lawmaker, right? And so we're asking not for a subjective test on the specific officer, but an objective test with the reasonable officer. And furthermore, unlike the statute in California that's interpreted, well, we don't know what the object is. Is this his name? Is it his driver's license? Is this route that he's jogging? We're saying it's the name, because our statute, unlike that statute, is crystal clear. It says name, okay? We think name means name, but your full legal name, not just part of it. And so now with respect to verification, okay, well, we think the name, if you look at it, it says his name, not somebody else's name, okay? And we're not dealing with grandmama's Sunday school class here. We're talking about criminal suspects. And on occasion, criminals have been known to lie. We have a few cases in our brief talking about lying criminals. A more recent example is Luigi Mangione, who shot and killed the head of United Healthcare. And the police officers were called to McDonald's. The girl thought he looked like him. They walk up to him. They ask him his name. It's all over the YouTube. You can look at it. And he gives a false name. Will the police officers say, okay, walk off? I don't think so, because they have a duty under the Fourth Amendment, okay, they have a duty to balance the legitimate governmental interests of investigating and preventing crime against the privacy intrusion of the individual. Okay, well, if the individual gives his oral name, okay, then it's not much of a privacy intrusion to give him your driver's license too. Because, yes, it includes other information, your height, your weight, and the color of your hair, but you've already given that to the state. They've already got it. They got it from you to put on your driver's license. And so it's not like a state secret here. And so we would also say this, Your Honor. What kind of test would say that a sovereign citizen, for example, could just say, nope, I'm not going to give you my license. I believe that I'm the King Ed of Dothan and I don't have to. Well, I'm not asking for an absurd test. I'm asking for a reasonable one. And then next, think about the vicious criminal. The most vicious criminals with the longest rap sheets have the most incentive to lie about their name because they don't want to get caught. They don't want something run on the computer on the LET system in Alabama because they'll get caught and arrested. Okay? And so the police officer has to, it's common sense. Right? He's out there in the middle of an alley at 2 a.m. in the morning with 3 suspects in front of him. He needs to find out who he's dealing with. Is it Otis Campbell or is it Jack the Ripper?
Mr. Haddon, while I have you on this end of the bench,
Yes, sir.
down here, I do want to ask you a quick shift of focus question. Is what the 11th Circuit ruled in this case important to us?
I think
'Cause they seem to have ruled on this issue.
Okay. The mandate rule. Your Honor, I think the answer there, if you look at Appendix F, page 2, Judge Proctor, is attached to my brief, Judge Proctor addressed that in his order directing the parties to brief whether this should be certified or not. And he said that a change in controlling authority is an exception to the mandate rule. And so he said, okay, well, if Alabama...
So you're saying what the 11th Circuit said is not important?
I think it's not binding, Your Honor. And it's not the mandate rule. I'm not saying it's not important. I think it's wrong. That's why we're here. Okay.
No, it seems like, respectfully, that the parties are appealing to us from an adverse ruling of the 11th Circuit within this particular case. And as far as the merits, I'm not so sure I disagree with you and probably the consensus of all my colleagues on the merits, but the procedural aspect, and we get a couple certified questions a year, but it's never in the context of a higher federal court has ruled and an inferior court is then asking us to rule contrary to that inferior court.
Well, Your Honor, a couple of things. When you talk about the mandate rule in federal court, it's different from the mandate rule in Alabama courts. In federal court, if the mandate doesn't keep you from doing something as a district judge, it doesn't expressly keep you from it, you can do it. You can have a new summary judgment, more evidence. You can have a new ruling if there's a change in the law.
What about the rule of the case doctrine, though?
Law of the case.
Law of the case doctrine.
Well, that's the mandate rule.
I think somewhat disagree. The mandate rule, I view it as a specific order from a superior court to an inferior court to do or not do something. The rule of the case or the law of the case doctrine is applicable, I think, where a higher court rules and it's an incorrect ruling, but nevertheless the inferior court must follow it. And by way of example, we've seen this sometimes in the context of, I know we had a case that was deflected to the Court of Civil Appeals. They ruled, it went back to the trial court. Then it came back the second time around, for whatever reason, this court kept it. And honestly, we believed that the Court of Civil Appeals was incorrect in reversing it to start with. But nevertheless, that became the rule in the case that we had to deal with. So I think there is a...
Okay, well, Your Honor, I would suggest that under Section 140B of the Alabama Constitution, this court has original jurisdiction to rule on cases of state law, certified questions. And this court is the final authority on Alabama law, not the 11th Circuit. And that decision in Jennings, in this case, does not bind this court. This court is not in a direct line of authority with that court.
Certified question is still discretionary with this court. So my bigger concern for me is It's more so the respect for the federal courts to do their job, which apparently the district court looked at it and ruled, did not think it was necessary for a certified question the first time. It goes to the 11th Circuit. They looked at it, did not think a certified question was necessary, and then sent it back to the district court, and now the district court thinks it is necessary.
Well, so I think you bring up an important question, and that is, if the 11th Circuit had ruled that we can't certify this question, we're not going to certify it. If the lawyers had asked the 11th Circuit, certify the Alabama Supreme Court, and they had ruled no, then I think the mandate would have prevented certification here. But the parties did not ask. It came from Judge Proctor, sua sponte, based on the exception, the express exception in the mandate rule for a change in controlling authority.
But are you, and again, I'm not, this is a
Justice Mendham, can you put your, sorry, you're going in and out.
Can you hear me?
I can, Your Honor.
Thank you. Now you made me lose my train of thought.
That's okay.
That may be good for Mr. Haddon. He's almost out of time. That's
We used to get on to it.
I'll let you move
I
on.
can ask one more question. on a different
Yes,
topic,
Justice Parker.
if you would like. I want to go to the obstruction statute for one just brief moment before you sit down.
Sure.
That's the kind of underlying offense with which Mr. Jennings
Right.
was charged. It requires him to have obstructed through means of intimidation, physical force, or interference. After watching the video, this is something that Mr. Jennings can respond to on when he comes up too, but I'm questioning about the intimidation or physical force. I don't know if those are bases for the obstruction or not, but I'm curious. I think it seems like the parties have litigated as if failure to comply with a demand under 15530 constitutes an independent unlawful act. Just wonder if you could speak to that point briefly, because I usually think of independent unlawful acts as something where it would be a criminal offense or violation or some sort, but maybe that's not the case. So I'm just curious about how to gel that phrase, independent unlawful act, with the way 15530 is framed as an authorization to law enforcement.
Right. Well, Your Honor, we would say that under 13810, there are two ways to do it, right? Physical force or interference, and we don't think interference requires physical force. We would say you don't have to do it, and we'd be happy to do just based on interference. But we've litigated under any other independently unlawful act. Well, 15530 says the officer can demand it. And if you don't comply with that demand, you just violated an act. And it doesn't have its own
So that's the
criminal
governmental
penalty.
function.
I'm sorry, Your
The
Honor.
request from the officer is the governmental function.
Well, the investigation is the governmental function.
Okay.
And so if you impede the investigation because they don't know who they're dealing with, are you Otis Campbell or are you Jack the Ripper? We don't know. And we think it's important that you find out. And so, Your Honor, we would ask this court to answer the certified question and have four things in your answer. One, that name means your true, full legal name, not a nickname or a half a name. The demand means the officer has a legal right to get an answer to that name. Three, that the test, because here we are in reasonable suspicion, is like the Terry test, whether a reasonable officer under totality of the circumstances has taken reasonable actions to get the name, address, and explanation of his actions. Then under that reasonable test, we suggest that verify is important because if you can't determine that it's his name, then the officer doesn't know who he's dealing with. And we're not, again, talking about Grandmama's Sunday school class. We're talking about criminal suspects. If there are no further questions, I'll sit down.
Thank you, Mr. Haddon. Mr. Daniels?
Real quick,
Mr. Daniels, before you get started and before somebody else jumps in, could you speak to the definition of demand that I asked? You heard my question. I won't take up your time, Matt.
yes, Your Honor. I believe that the word demand allows officers to demand those things that within the statute verbally, once that question is being asked. It's not, and I think the officer has a right to demand that information.
But not to demand a document to verify. So demand does not include verify. Is that your position?
That's correct, Your Honor. I think the plain meaning reading the statute clearly states that what is in this statute, what they can ask for. There's no document and no driver license, no ID. And I think the legislation intent is very well laid out, not just in this statute, but future legislation bills that's going before the legislation as to they could have put in that proposed amendment 30 House Bill 34 driver's license or documents or ID. They did not. The only thing they that's been pushed in that bill is date of birth to further identify a person. Your Honor,
Can I ask you a question? I'm sorry, also in response almost to this.
Okay.
So your position is the officers are required to ask the name, address, and purpose of being there before they can demand further proof?
No, Your Honor, they can demand that the name, address, and explanation of your action.
Correct,
They can demand that.
the officers have to ask those questions first before they then can require verification? Is
And,
that your
and I think the word's required. So to answer that question, they can ask for ID immediately, but in order to when they ask for verification of other documents, is our position they cannot ask for the documents at all, for ID or driver license at all. And I think my friend across the aisle here talks about that the criminals lie all the time. They absolutely lie all the time. They lie, say they don't have drugs in the vehicle, and they in fact have drugs in the vehicle. But the constitutional rights, if the officer violates their constitutional rights, guess what? That evidence is suppressed and they get to go home, regardless of the lie. So the issue is investigation. The officer has to engage in investigation. And this court, with the statute, the law in Alabama, law the officers to engage in investigation to identify that person, short thereof trying to compel driver's license. Now, when I was sitting here, Your Honors, I felt like that we was really rehashing the argument in this case all over again, that we argued in the district court and in the 11th Circuit. And Your Honor brought up the law of the case doctrine, particularly. And this focus on that particular area, we're talking about that this issue about whether there was some type of independent action or independent violation where Pastor Jennings, Michael Jennings, could have been arrested. Even the district court said there was no independent action. He said that. Judge Proctor said that. The 11th Circuit echoed that as well. So there was no...
You're out of time. If you just want to, 4 words or less.
Judge Proctor, he acknowledged there was no independent action that required the officers, that allowed the officers to arrest me. Your Honor, we asked that this question be answered in the negative. And thank you for your time.
Thank you.
And thank you all. Thank you.
Thank you all very much for your time. We are appreciative of the arguments and the time that you took to prepare, and we'll take this under submission and get a ruling out shortly. Thank you.
All rise. Court is adjourned.